Second DUI in Pennsylvania. How the penalties change, and what you're really facing. If you've been arrested for a second DUI in Pennsylvania, or a third, you already know this doesn't feel like the first time. And you're right, it isn't. A repeat DUI in Pennsylvania is not handled like a rerun of your first case with a bigger fine. The penalties escalate, the options narrow, and the consequences can reach parts of your life that the first arrest never touched. I'm Sean Quinlan, Pennsylvania DUI attorney based in Camp Hill. This is what you actually didn't need to know if you're facing multiple DUI charges in Pennsylvania. The 10-year look back, the number that changes everything. Before anything else, you need to understand the single most important concept in a Pennsylvania repeat DUI case, the 10-year look back period. In Pennsylvania, prior DUI convictions, and in some situations, certain prior DUI related resolutions, count against you if the earlier case falls within 10 years of your new offense date. Notice I said offense date, not arrest date, not conviction date. The date that usually matters is when the prior offense occurred compared to when the current one occurred. That timing distinction matters enormously. A prior case that sits just inside that 10-year window can trigger mandatory minimum penalties that would not apply if it sat just outside it. One date on a docket can be the difference between a lower sentencing range and a dramatically harsher one. So if you're sitting here thinking, that was years ago, it probably doesn't count, don't assume. Get the exact dates. Because if that prior case falls inside the window, your new arrest is almost certainly being treated as a second or a third offense, and that changes almost everything. Why penalties escalate the way they do? Pennsylvania treats repeat DUI offenses as a bigger public safety problem, so the system responds by adding more of everything. More jail exposure, higher fines, longer license suspensions, and more treatment requirements and ignition interlock. Think of it like missing multiple payments instead of one. The first missed payment might get a warning or a manageable fix. After that, the system assumes the earlier response didn't work, so the consequences get sharper. A repeat DUI is not a first DUI with a bigger fine. That's the cleanest way to understand it. And the tier of the offense matters enormously here. Pennsylvania sorts DUI cases into 3 tiers: general impairment, high rate, and highest rate. And a mandatory minimum means the court cannot go below a certain punishment once a conviction is entered at that tier. The higher your BAC, or if drugs are involved, the faster those minimums escalate on a repeat offense. Second DUI penalties in Pennsylvania. Let's get specific about what a second DUI actually looks like. General impairment, second offense. This is the least severe tier. Mandatory minimum of 5 days in jail. Fines of up to $2,500. A 12-month license suspension is common, though some general impairment second offenses may have different suspension outcomes depending on the facts. High rate second offense. Mandatory minimum of 30 days in jail, fines of up to $5,000, 12-month license suspension, treatment requirements. Highest rate or drug DUI second offense. Mandatory minimum of 90 days in jail, fines of up to $10,000, 18-month license suspension, more extensive treatment required. That jump from 5 days to 90 days based on tier is not a minor distinction. It's the difference between a manageable disruption and a life-altering one. And here's what makes these numbers feel real. Once mandatory minimums apply, a judge cannot simply go below them because your background is sympathetic to or your circumstances are understandable. The floor is the floor. That's why the tier of your current charge and the timing of your prior offense need to be examined carefully, because they set the parameters for almost everything else. Third and subsequent DUI penalties. By the time a third or later offense is in play, the pressure ramps up dramatically. General impairment third offense, mandatory minimum of 10 days up to 2 years. Fines up to $5,000, 12-month license suspension. High rate third offense, mandatory minimum of 90 days up to 5 years in jail. Fines up to $10,000, 18-month driver's license suspension. Highest rate or drug DUI third offense, 1 to 5 years in jail. Fines up to $10,000, 18-month suspension. And this is where felony exposure enters the picture. A felony DUI is a different weight than a misdemeanor in almost every area of life. Employment screening, housing applications, professional licensing, and in some situations, firearm rights. A misdemeanor DUI is serious enough. A felony DUI carries consequences that reach significantly further and stay longer. For most people, the license hit is the first place a repeat DUI disrupts daily life, and it often lands before anything is resolved in court. A 12-month suspension at many second offense tiers and an 18-month suspension at higher tiers for second and third offenses means getting to work, managing childcare, making medical appointments, and meeting any court or treatment requirements all become logistical nightmares, not just legal ones. And when that suspension ends, getting back on the road usually requires more than just waiting out the calendar. Restoration fees, completion of required classes and treatment, ignition interlock, the breath testing device installed on your car that requires a clean sample before the engine starts. Miss any of those steps, and the restoration process stalls. CDL holders face an especially harsh reality here. Commercial driving privileges are governed by stricter rules, and a repeat DUI can threaten your ability to earn a living in ways that hit much faster than the criminal case itself. The options that might apply for a regular license, occupational limited license for example, certain driving related arrangements, don't translate the same way to a CDL world. The two tracks, criminal court and PennDOT. Here's a point that causes real confusion and needs to be stated clearly. The criminal case happens in court. Your license consequences are handled through PennDOT. Those are connected, but they are not the same process. Fixing one side does not automatically fix the other. You can have progress happening in court, while a license suspension is building on a completely separate administrative track. And people get caught off guard by this constantly. They think the court case is the whole problem, and then PennDOT sends a notice that starts a separate clock. If you're dealing with a repeat DUI, both tracks need attention from day one, not just the courtroom side. The extra layer for the licensed professional. If you hold a professional license, nurses, teachers, healthcare professionals, contractors, or any other licensed field, a repeat DUI creates a second layer of exposure on top of the criminal case. Board reporting rules, employer policies, renewal disclosures, and background screenings can all be triggered by how the charge is graded and how it is resolved. The criminal case is one problem. The licensing and employment fallout is another, and it doesn't always wait for the courts to finish. This is why the outcome of the criminal case matters well beyond the fine and the court date. A charge that gets reduced or resolved favorably has a different impact on licensing board review than a straight conviction at the highest tier. That difference can affect your career for years. What can actually be done? Here's what I want you to take away from this. A DUI arrest is not a conviction, and a repeat DUI arrest doesn't mean that the worst version of the outcome is inevitable. Details matter, and in repeat DUI cases, specific details can change the entire picture. The traffic stop. Police need a lawful reason to stop your vehicle. If that foundation is shaky, what was built on top of it may be challenged. Testing procedures. Breath machine calibration, blood draw procedures, chain of custody, timing issues. These come with rules. Problems in any of those areas can affect the reliability of the evidence. The look-back window timing. The exact dates of the prior offense relative to the current one. Sometimes what looks like a second offense on the surface doesn't count the way the initial paperwork suggests. Charge tier. Whether the facts supported the tier charged, or whether there's a basis to challenge it. Treatment alternatives. In some cases, depending on the tier, the county, and the facts, treatment credit, inpatient programming, or house arrest may provide some relief from the harshest sentencing outcomes. These aren't automatic, but they're worth understanding. ARD for a second or third DUI? Generally no. ARD is aimed at first offenders in Pennsylvania. For repeat offenses, it's typically off the table. But that doesn't mean there are no options. It means the strategy shifts towards challenging the evidence, negotiating charge tier, and identifying sentencing alternatives where they apply. A second or third DUI in Pennsylvania is serious. But serious doesn't mean the outcome is already decided. The tier of the charge, timing of the prior offense, the quality of the evidence, and how the case is handled can all affect where things land. Do this right now. Gather your current charging papers and find the date of your prior DUI offense before your first consultation. That timeline is often the first thing that drives everything. From how the case is graded, to what mandatory minimums apply, to what options are still available. If you're facing a second or third DUI in Pennsylvania, or want to understand exactly where your case stands, reach out. Free consultation, no pressure. Link is in the description. Subscribe for more straight talk on Pennsylvania DUI law. See you in the next video.